Hello, everyone, and welcome to the final round of this year's Dean's Cup competition hosted by the Moot Court Board. Started in 1963, the Dean's Cup is Duke Law's premier oral advocacy competition open to 2Ls and 3Ls. Before we get any further, we'd like to say thank you to the people who helped make this event possible. Thank you to Dean Abrams and to Professor Andrew Sear, to the clerkship and events offices, and a special thank you to all of the faculty, staff, and alumni who judged the preliminary and semifinal rounds. 31 competitors participated in the preliminary rounds. From this, 8 semifinalists performed in several more rounds and submitted written briefs. The top competitors, the top advocates from each side of the case, are today's finalists. Our finalists today include Eric Tucker for the petitioner, Casa de Maryland, and Jenny Wheeler, representing the Department of Homeland Security, the respondent. The finalists will argue a fictional Supreme Court appeal from the Fourth Circuit's decision in Casa de Maryland v. Trump. The Immigration and Nationality Act empowers the United States to exclude or remove aliens whom are likely to become a public charge. Traditionally, this term has until recently generally been understood to mean someone who is reliant on cash benefits from the government for subsistence or who experiences long-term institutionalization. However, in 2019, the Department of Homeland Security promulgated a rule expanding the definition of public charge to, among other things, include consideration of non-cash benefits such as food stamps and Medicaid. At issue in today's case is whether the Department of Homeland Security's definition of public charge is contrary to law or in excess of statutory authority under the Administrative Procedures Act. Our finalists will argue before our esteemed guest judges, the Honorable Anita Earls of the North Carolina Supreme Court, the Honorable Goodwin Liu of the Supreme Court of California, and the Honorable Allison Jones Rushing of the U.S. Court of Appeals for the Fourth Circuit. More information about our finalists and our guest judges can be found in the program. We'd like to extend a special thank you to our impressive guest judges for taking the time out of their schedules to participate in this competition. We do ask that while arguments are ongoing, that you please remain in your seats, silence your phones, and refrain from talking. And please do not applause in between the advocates' arguments. We will begin momentarily. Thank you. Thank you. All rise. The Honorable, the Chief Justice, and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention. The court is now sitting. God save the United States and this honorable court. You may be seated. We have a special session of the United States Supreme Court today. It is the Dean's Cup final at Duke Law School. We'll hear argument in number 19-2222. Petitioner, are you ready? Yes, Your Honor. You may begin.
Mr. Chief Justice, and may it please the court. My name is Eric Tucker, counsel for the petitioner in this case, Casa de Maryland. With the court's permission, I would like to reserve 2 minutes for rebuttal. Your Honors, this case is about a new public charge rule that DHS has promulgated that sets aside more than a century of legislative and executive branch interpretation and practice. This court should reverse the judgment of the Fourth Circuit. It should hold that this rule is contrary to law and in excess of DHS's statutory authority for the following two reasons. First, for more than 100 years, Congress, the courts, and the executive branch all concluded that the public charge provision conveys a single standard. Only those likely to become primarily dependent on the government are excludable as public charges. And second, even if this court had concluded that the public charge provision contains some ambiguity, the rule is still unreasonably divorced from the standard's text, structure, and history. When Congress passed the first federal public charge provision in 1882, it was not legislating on a blank slate. In fact, multiple state Supreme Courts had already construed the phrase public charge as a term of art that was limited in its context to people who were primarily dependent on the government. The Supreme Judicial Court of Massachusetts noted in the city of Boston, for example, that a public charge meant the person had to be a heavy and long continued charge because of permanent disability. The Illinois Supreme Court agreed.
So was that practice uniform so that it could be considered a term of art, or was there variation?
It was uniform, certainly, Justice Rushing, among important Supreme Courts where there were significant immigrant populations. For example, Boston was a heavy immigrant population.
Was that a way of saying it was not uniform?
We would argue, Your Honor, that it was uniform when the Supreme Courts were construing it as a term of art in that phrase. Not every state immigration statute had the words public charge in it, but when the state Supreme Courts were interpreting and using that phrase specifically, it was uniform based on primary dependence. This is not simply the case in the city of Boston case in the Massachusetts Supreme Court. The Illinois Supreme Court further agreed, noting that to be a public charge, the non-citizen had to be poor, unable to earn a livelihood, and not have any supporting relatives. These state Supreme Court opinions, combined with the ordinary meaning as defined in contemporary dictionary definitions like Webster's Dictionary, 1828, showed the settled meaning when Congress passed the 1882 Act. And it's further demonstrated by the text of the 1882 Act itself. The entire public charge provision excludes any convict, lunatic, idiot, or any person unable to take care of himself or herself without becoming a public charge. Later iterations of the Act, like the 1907 Act, included further qualifiers like paupers and professional beggars.
Do you construe so just to go to the text here of the 1882 Act, do you construe this delegation to the Secretary of the Treasury not to encompass an interpretation of this term?
We certainly do not disagree, Mr. Chief Justice, that there was some delegation given to the administrative agencies in 1882 and that there's still some delegation in 2022 now, of course, to DHS. But what Congress was demonstrating when it used the word public charge in this language is that the discretion given in 1882 to the Secretary of the Treasury was to implement the public charge provision according to that standard of primary dependence. And the reason that that standard is important is because, as the history has demonstrated, there are a myriad of factors that can influence primary dependence, which would
Hasn't Congress over the years only increased its emphasis on the discretion? We have the Supreme Court case where the court construed the term by its neighbors or paupers, and Congress actually moved to the term and said, no, that's not what we mean. Should we read that to mean that they're emphasizing the discretion to interpret the term?
We would argue that the Gigao decision and the movement of that phrase afterwards, as demonstrated actually by the Article III Circuit Court history, did not cause a significant change in the definition of public charge. Of course, the Adjurum Genesis canon would still apply to the end of a list of limiting language as well as in the middle of it. And the language itself was never changed, and Congress didn't pass any affirmative definition when it...
Well, that's a little, you say Congress, in reaction to the Supreme Court case, Congress moved the term. They tried to do something, but you say, well, the same canon of construction would apply, so they really did nothing.
Well, that depends on the judicial interpretation of what Congress did when it was passing the 1917 Act. In fact, the circuit courts interpreting this soon afterwards determined that Congress was not passing the movement of the language in reaction to Gigao to change or narrow the definition of public charge. The Fifth Circuit, for example, in Koikendo v. Skrmeta, noted that it cannot be well supposed that the words in question were intended to refer to anything other than a condition of dependence on the public for support. That's a decision that was passed or held by the court interpreting the 1917 Act, not the 1882 Act.
What did Congress do when it moved it? What did that accomplish?
Well, there could be a number of reasons, Your Honor, that Congress remove that word. It did add additional limiting qualifiers to the public charge provision, and it could have presumed that it would have made more sense to include the phrase public charge at the end rather than in the middle. But what's important to note is that all of those additional qualifiers added in the 1917 Act still had a similar common denominator of primary dependence. That didn't change it. There weren't additional qualifiers that would have expanded the scope. And that's why
Could I return to your argument then about 1882 and what you say is the settled meaning? Isn't context important here just in the sense that in 1882, we didn't have what you might call today a social welfare state, did we? I mean, Congress would not have had within its contemplation the full range of public benefits and programs that exist today. And so it wouldn't have been perhaps unnatural for Congress to have focused on what was essentially the most destitute or the sort of most needy being provided for through the public fisc. But that doesn't mean that Congress had only that in mind. That's just an indication of what the conditions prevailing in the society were. We have lots of cases like this where a term is chosen, but society changes, and the term, has no fixed meaning, and then becomes adaptable, over the age, especially when you're talking about statute.
It's certainly true that in 1882, the public welfare system did not exist to the capacity that it does today. And there are certainly public benefits that exist now that didn't in the 1800s. But the context of the 1882 Act is actually very helpful in showing why the definition DHS now advocates before this court is one that Congress precluded. Because the public charge provision was passed actually in Section 2 of the 1882 Act, not Section 1. But in Section 1 of that very same Act, Congress created something called the Immigration Fund. And what this fund did is it used a tax on non-citizens entering the country, compiled those funds, and then provided them as short-term benefits to non-citizens entering the country. So in other words, in the very act that created the public charge provision at issue today, Congress expressly provided the type of short-term supplemental benefits that DHS now argues would make a non-citizen excludable as a public charge. So while it's true that the types of benefits that exist today might be larger in volume.
But counsel, these are just all questions of degree, right? I mean, it's not that any receipt of any benefit makes you excludable. There are criteria, 12 months and within a 36-month period. You could choose different numbers, right? And the point is that if you're Congress and you're legislating a broad policy, which I assume this is, why wouldn't the natural inference be that Congress chose to have an adaptable statute, right? That would be useful depending on the political judgments made in different economic times, depending on the nation's needs, from era to era.
We agree, actually, Mr. Chief Justice, that this is an adaptable statute that Congress has passed. That's why it's created a standard of primary dependence. And the problem with the rule that DHS is now arguing before this court is that it's not in any way a reflection of the history of how this statute has progressed and been adapted and been adopted. What it does is it creates a de minimis application of benefits for a de minimis period of time over some indefinite time horizon, because this is a prospective inquiry. What immigration officials are trying to determine under this rule is if a non-citizen at the border is likely at any time in the future to receive this vast list of qualifying benefits, which, as we note on page 84 of the Joint Appendix, are benefits that about half of United States American citizens are expected to receive in their lifetime. That's never been any type of self-sufficiency definition one would understand, and it certainly doesn't meet primary dependence. That's why even if this court were to conclude that that definition of public charge is ambiguous, the rule is still unreasonable and contrary to law because it goes far beyond the bounds of what public charge has ever been understood to mean in nearly 150 years and any type of parameters of discretion that Congress would have given to the Department of Homeland Security. In fact, in the 1990s, Congress actually rejected a bill that had a very similar type of aggregation threshold as the rule does in this case. This was H.R. 2202, which was considered during the IRA in the 1990s. In fact, that bill was actually less restrictive than the rule here because the list of qualifying benefits was
Isn't it a little dangerous to be reading into what Congress didn't do, especially if the fact that they didn't adopt a definition means they left it for the agency to fill that gap?
Well, Justice Rushing, Congress didn't simply reject a bill that was put before a committee, and then that was the end of the matter. Congress did actually amend the public charge language in the IRA when it passed it in the 1990s. And it added a list of flexible factors for immigration officials to be required to consider when making these determinations. These included the age, the health, the educational status, the familial status of the non-citizens. So Congress was actually rejecting the type of benefit-based definition DHS now argues, and instead chose to pass other language. And while that doesn't have to be considered in a vacuum, it's certainly more authoritative evidence that Congress has expressly precluded the type of definition DHS now advocates before this court. In fact, the immigration courts had already rejected this types of benefits-based definition in addition to Congress. In the matter of Martinez-Lopez, for example, the Attorney General and BIA noted that a healthy person in the prime of life cannot ordinarily be considered likely to become a public charge. That standard certainly does not apply under the rule that DHS has argued today. And the other problem with this rule on its unreasonableness is, again, the type of benefits that qualify is a list that has simply never been seen in the history of this country, even as the welfare state increased in the 1900s. Now, a non-citizen who receives an average allotment of SNAP benefits for a year, which is about $800, the cost of last year's iPhone. If an immigration official at the border is to determine on a coin toss that essentially those non-citizens are going to incur that type of benefit, again, at some point in their lives, they can be.
Counsel, I missed the part of the regulation where they toss the coin. Can you point me to that part?
Well, the coin toss, then, Justice Rushing, kind of, again, refers to the types of qualifying benefits that now fit here. Again, these are benefits that up to 50% of Americans are expected to receive in their lifetime. That's a coin toss. That's 50% of people in this country. So what DHS is, in this prospective determination, trying to determine is if under this very specific de minimis application of rules for an indefinite time horizon, if people will receive those benefits, then they can be excluded from this country as a public charge.
I don't want to take all your time. I do want to ask a question about the context that we're in. Should we be considering the fact that immigration law is something that's especially committed to the political branches? It's especially within the executive's prerogative to decide how we define who is allowed to enter the country. Should that have any weight in our Chevron and separation of powers balance here?
We don't dispute that DHS has discretion in this case, as it does as an agency, not only under the statute, but under contemporary immigration law. But discretion is not a blank check. And that's what DHS is advocating before this court. It argues that essentially because Congress hasn't explicitly defined the words public charge, that it has a green light to enact this type of rule that not only has never been seen in more than 100 years of history, but actually defies decisions by this court, by the lower federal courts, and by the immigration
Well, to that point, could I just, add more, which is to say, is there anything wrong with Congress, this is to your 50% point, preferring the people who are here rather than the people who seek to be here? Isn't that the essence of sovereignty? Is that those kinds of preferences are perfectly reasonable?
I do see that my time has expired, Mr. Chief Justice. If I could briefly answer your question. There certainly can be differences between the types of benefits we would expect non-citizens to receive versus American citizens. But that type of vast list of qualifying benefits, that's never been seen under the text, structure, or history of this act. If Congress were to make that determination, we wouldn't expect it to be done in a term that has not been defined. And actually, the type of definition, again, has been affirmatively rejected by Congress in the 1990s. And actually, again, when it rejected a similar version in 2013. For those reasons, this court should reverse the judgment of the Fourth Circuit. It should hold that the rule is contrary to law and in excess of DHS's statutory authority. Thank you.
I'll hear from the respondent.
Mr. Chief Justice, and may it please the court. My name is Jenny Wheeler, counsel for the respondent, DHS. Your Honors, this case is about maintaining this court's long-standing deference to reasonable agency interpretations of ambiguous statutory terms. Because the statutorily undefined term public charge is ambiguous, and because DHS's public charge rule is a reasonable interpretation of that term, we ask this court to affirm the Fourth Circuit's ruling. First, to say that the statutorily undefined term public charge is unambiguous defies the 140-year history of that provision. Rather, those 140 years reflect a consistent intention of Congress to leave the term statutorily undefined and instead to vest discretion in the executive branch to interpret and enforce the provision. We can see that the provision is ambiguous by looking to 4 years, 1882, 1917, 1952, and 1999, 4 major inflection points in the public charge provision's history. Turning first to the year 1882. As petitioner noted, this was the first appearance of the public charge provision in national immigration law. However, even though there were state laws that similarly excluded public charges, Congress did not import some kind of settled definition when it enacted the 1882 Act. We can see that by Congress's inclusion of other categories of grounds for inadmissibility, and moreover, its decision to vest discretion in the Secretary of the Treasury. In a report to Congress, the Assistant Secretary of the Treasury said that to assign a single definition to the term public charge would be impracticable and unworkable. Instead, at that time, the determination was being made according to the, quote, personal feeling and judgment of the immigration officials. Moreover, the immigrant...
Please.
I was going to ask, is it possible that it was more straightforward back then to figure out this question? I've been baffled at the sort of future-looking question that the immigration official is supposed to ask here about, will this person at some point in the future be dependent on some sort of public benefit for 12 months within 3 years? You know, we have so many public benefits now that they have to consider under this rule. And it struck me as that it would be much easier to perhaps to predict, will this person be dependent on federal benefits or completely impoverished?
Your Honor.
As we've been talking about, the benefits that were available when this was originally enacted are very different from what we have now. So is that a difference that weighs in our decision making here?
Your Honor, I would not agree that it was an easier determination at that time. However, I would suggest that it was a more superficial determination at that time. As I said, it was left largely to the immigration officials' personal feeling when they saw the immigrant. Today, DHS is guided by 5 statutory factors. They look at the immigrant's age, their health, their family status, the assets and resources that they have available to them, as well as their education and skills. So that kind of holistic and totality of the circumstances inquiry allows DHS and its officials to determine their employment prospects, the burden of support of caring for children, and other obligations that they might have. And moreover, to your second point regarding the administrative state and the rise in the last half century of that, this goes back to the Immigrant Welfare Fund. That provided for immigrants in distress. It did not specify a duration of dependence, and it did not specify a degree of dependence. And that is entirely different from the myriad sorts of benefits that are available today. The public charge rule at issue here includes SNAP benefits and Medicaid benefits and housing benefits because these are all basic necessities. So at that time, there were not these basic necessities being provided to the immigrants, so it would not have made sense for them to be included in the statute at that time.
Had any official, just to go back to the turn of the century period, had any official authority construed public charge to mean anything other than primarily dependent?
Your Honor, I would say that no official had construed it to mean primarily dependent. That definition first appeared in the 1999 field guidance issued by the INS. In fact, what the case law shows is that the degree of dependence or the duration of dependence was never indicated. Turning to the case that petitioner cited, the matter of Martinez-Lopez case, which was a decision by the Attorney General who was charged with enforcing the provision, that opinion merely says that a healthy person in the prime of their life normally cannot be considered likely to become a public charge. And it goes further and says, especially where they have friends and family that they are likely to be able to rely upon for support. However, the public charge rule is not inconsistent with that. First, health and age are 2 factors that go into the inquiry, as I mentioned previously. And second, looking to see if individuals have friends, or family to rely on for support is a source of private support, and it negates becoming a public charge. So that primary dependent standard simply never appeared until 1999, which the field guidance recognizes when it says that that is a reasonable interpretation given the history. The public charge provision sets a floor, and above that, anything that is above that floor is reasonable. The primary dependent standard is reasonable, but DHS's public charge rule is also reasonable.
I want to ask you about the reasonableness of the rule, and in particular, the assertion that it would essentially cover half of Americans. Doesn't that suggest it is, in fact, way too broad?
Your Honor, the contention that it would cover half of Americans by petitioner is actually imprecise. So that data did suggest that more than 50% of Americans take advantage of a public benefit in their lifetime. It is not constrained to 12 instances of benefit distribution within a 36-month period. So those are not all being swept into the rule. And as the Chief Justice noted, it's reasonable for Congress to make distinctions between persons that are in the country and persons that are seeking to be admitted. There are simply more immigrants that would like to enter the country than the United States can admit. Moreover, Congress has recognized that there are different reliance interests for persons that are in the country. There's a public charge rule for deportation purposes, and that is not changed by the public charge rule here. The rule at issue in this case deals only with admission and adjustment of status. So Congress has recognized those reliance interests at deportation and set a higher threshold for those.
But it seems to me the more specific you make the rule in terms of who can enter the country, doesn't that make it harder to actually predict with any reliability?
It can make it harder to predict, Your Honor, but this is a prospective inquiry, and it's about two primary goals which Congress has stated are goals of immigration policy, which are 1, to protect the public fisc, and 2, to promote immigrant self-sufficiency. And so by setting this threshold and taking into account those 5 mandatory statutory factors, we look at the immigrants' employment prospects and we determine if they're likely to have gainful employment. And notably, the fact that the provision stacks the benefits, that goes to the portion that Congress has stated that immigrants should be self-sufficient. So this goes to show that if someone is receiving, for example, 3 benefits in 1 month, we'll say SNAP benefits, Medicaid, and housing assistance. Those are 3 basic necessities of life that they're having to rely upon the government for their support. Whereas someone that receives only 1 single instance of benefit distribution is more self-sufficient.
Raises an interesting question, I think, about what would be an unreasonable interpretation. If you stack these, so I think the 3 benefits, if you had 3 benefits for 4 months, that would be your 12 months, right? So is it unreasonable to say that someone who is dependent on the government for 4 months is a public charge? You say no, because that's your rule. What if it's someone who is dependent on the government for 2 months?
Your Honor, I would say that there is a certain floor to the public charge provision, and we can see that from the history of the provision. So going back to the 1882 Act that created a welfare fund for persons in temporary distress, that indicates that we do want to make carve-outs for persons that have short-term needs of government support, especially when they're just entering the country and need the support to help themselves. So there is a threshold. I am not comfortable articulating what that would be.
It's the government's position has to be that someone who is a pauper for 4 months, that person is a public charge and cannot be admitted.
Yes, Your Honor, that is our position because that person has necessarily shown themselves to not be self-sufficient. And this rule is also about drawing a line where DHS determines that the immigrant is overly reliant on the government for support and thus overburdening the public fisc. So in that instance, when they are not being able to provide for themselves, that does show.
How are we to, I don't want to keep harping on this, but I do want to ask, how are we supposed to determine what is temporary? You point to the provision to provide for immigrants who are in temporary distress, but it sounds like you're saying for us to determine whether this is a reasonable interpretation, we have to figure out what counts as temporary, and how do we do that and where do we draw that line?
Your Honor, I would disagree that the court has to make the decision of what is temporary. Instead, I believe that has been vested with the executive branch. And in this case, DHS has drawn that line at 12 instances.
I think that the question is asking you, what are the limits of that? Because I think the position you're advocating sounds like there's really very little role for any judicial review here. What would be an example of an unreasonable interpretation of this statute?
Your Honor, I think an interpretation that said a single instance of benefit distribution, a single instance, for example, of SNAP benefits for 1 month or perhaps 2 months.
About 6 months.
That gets closer to the line of 6. And
Sure, 6 is closer to 1, but what's the answer?
Your Honor, I don't think that that would be per se unreasonable, because we can see Congress has stated that it's not intending to broadly distribute benefits to immigrants. We see this in the 1996 amendment, the Welfare Reform Act. This actually imposed a 5-year moratorium on benefit distribution to immigrants for the first 5 years after they enter the country. So Congress has stated that the availability of benefits is not meant to be an incentive for immigration. So it draws the line and makes sure that persons are able to access benefits after the fact if they run into hard times or need temporary assistance, especially.
Well, I guess that is a very, I mean, that puts the courts in a very difficult place. Because essentially we are now in the position, right, of having to make a policy determination as to where the line is for self-sufficiency. Otherwise, the step 2 argument about unreasonableness really admits of no real judicially manageable standard, right? You have to suggest to us, I think, if you want to bound this argument in some way, a rule or some sort of definition that this court is supposed to adopt. You say 1 is too little, 6 is okay, 12 is certainly okay. That's not a rule. That's just a series of data points. So what's the rule?
Your Honor, I would say that the history of the public charge provision shows that there is not an easily administrable rule, but rather we have to make carve-outs. And so we can see that the rule that renders 1 unreasonable and 6 reasonable comes from the history that shows we will provide for some instances where a person is in temporary distress or in temporary need. And moreover, I would say that the kinds of benefits that are considered could also render the rule unreasonable. And the fact that certain benefits are excluded from DHS's public charge rule shows that it is not unreasonable.
Why is this, given how difficult all this is and the number of judgment calls involved, why is this a valid delegation to the agency here? You said a couple answers ago that Congress clearly could prefer certainly could prefer citizens to non-citizens and can prefer to draw the line at one place rather than another. And no one could disagree with that. But the point here is that the agency, not Congress, is making these determinations. And one would think, boy, this is really a vast range of policymaking that's going on here.
Your Honor.
And in fact, it's a kind of policymaking that then is not very susceptible to judicial review because of the lack of standards.
Your Honor, immigration policy is an area that is especially given to Congress to partner with the executive branch. They need to speak with one voice, so it makes sense for Congress to delegate to the executive branch. Moreover, the authority for Congress to delegate is very low. For there to be a non-delegation issue, you need only have an intelligible principle. Congress has given an intelligible principle by outlining the mandatory statutory factors that DHS has to consider. And moreover, it's repeatedly emphasized that it wants to give the executive discretion in that case by never defining the term in its 140-year period and instead giving that discretion to the executive branch. What the 140-year history of the public charge provision shows is that there are many reasonable interpretations. Public charge rule is one. We ask this court to affirm. Thank you.
Thank you, counsel. Rebuttal, counsel.
I have 2 points. First, I want to start by talking about the self-sufficiency justification that DHS just argued before this court. It's true that Congress has noted at times that it's important that non-citizens arriving in this country are self-sufficient. But this rule does not meet the self-sufficiency principles the DHS just argued. One would not argue that receiving $800 in food stamps necessarily makes somebody not self-sufficient. That's the problem with what this rule does. It doesn't fit the rationale that DHS is arguing, because this rule has a de minimis number of benefits that stack, that can be determined at any time in the future. Again, the list of benefits being so huge that half of U.S. citizens are expected to use them at some point in their lives.
Why is that not, I don't follow, why is that not a valid definition of self-sufficiency? You may disagree with it, but why is that not one reasonable version?
Well, Your Honor, it's not reasonable because it simply doesn't meet the common sense definition of self-sufficient that anyone
Who's
would
common
argue.
sense?
Well, for one thing, the legislature actually, in rejecting one of these types of benefits, explicitly noted that a public charge limitation like this one would actually make it harder for non-citizens to become self-sufficient. That's one of the reasons that Congress created the Immigration Fund in the 1882 Act. It recognized that in adjusting to entry into the country, non-citizens might need to receive certain short-term relief to help them get on their feet and become self-sufficient. This is knocking them off of their feet. It's actually undermining a purported goal of self-sufficiency. And second, I want to talk about the floor that DHS has argued is inherent in the public charge provision through the weight of history. DHS said that there was a floor, but declined to answer what that floor was. She did not answer to this court what would make this rule unreasonable, that simply 1 month of benefits might be fine, but 6 months probably is okay, and 12 months certainly is. What that essentially argues is because Congress didn't explicitly provide a definition, DHS has all the discretion in the world to enact a rule that defies over a century of uniform practice. Again, DHS did not point to...
I suppose the question then is, what is the floor from your perspective? I'll go ahead and give you a dispensation to answer. If accepting that DHS has lots of discretion here because Congress has repeatedly given it to them, where is this floor that we say they cannot go below?
Well, two answers, Your Honor. First of all, we would argue that the primary dependence standard that's been considered for over 100 years gives this court a very good starting point to conclude where that floor would be. Even if this court were to find that it wasn't exactly primary dependence, some level of substantial dependence on the government's support is what the history of the public charge provision demonstrates, not simply receipt of a short-term supplemental benefit. Again, Your Honor, this court should reverse the judgment of the Fourth Circuit because the rule is unreasonable, contrary to law, and in excess of DHS's authority. Thank you.
Thank you, counsel. We have your well-presented arguments in mind. The matter is submitted.
All right. Y'all can sit. While we wait for our judges to deliberate and announce the winner, let's have a round of applause for our excellent finalists. Please be seated.
Well, you didn't make our job easy. That's all we can say. Congratulations to both of you on such an incredibly fine performance. Both of you were tremendously prepared, persuasive, articulate, thoroughly researched. I will say for myself that we would be lucky to have attorneys of your quality appear in real life in our court. I think that's fair to say. And I think any one of you who watched this argument know that whatever separates these two people is only going to be by a hair's breadth because both arguments were truly, truly fantastic. So, but forced to decide, as we did, we have decided that the Dean's Cup final moot court award will go to Eric Tucker. And we'd like to spend a few minutes to just talk to the two of you and all of you who are watching today about just our observations about oral argument and maybe some tips and thoughts that we have from our own experience on the bench. So I'll start with Justice Earls.
Yes, well, thank you so much. I, of course, echo what an incredible argument this was and how difficult you made our job. But just a couple of observations. So, Eric, you handled being pressed really well. You came in with a really clear understanding of the structure of your argument, and you were able to go back to that after answering questions. You made a really good use of cases and precedent, and you conveyed confidence in your position while at the same time, engaging in dialogue with us. And so it was just a really excellent presentation, a great conclusion. It's always nice when you tell us what you want us to do. So that was really good. Jenny, you were also completely prepared, able to go right back to your argument after answering questions. You had good ability to also use cases, use precedent, support your arguments well. And I thought that you can also tried to explain to us what the government was doing in a way that was reasonable and made sense. So thank you. It was really a great argument.
So again, to echo what's already been said, this was an impossible choice. You both did a fabulous job. We talked about how we were impressed by, and I will say this personally, I was very impressed with both of you and your ability to answer our questions conversationally and transition it back into your argument. That is something that is very difficult even for the most seasoned litigants to, even people who think they're good at it will answer the question and then say, now to get back to my third point, which is fine. But you were so much better than even that. And you really made it a conversation with the bench, which is what we are hoping for. And if we really had to decide this case, that's what helps judges decide. Having been on the other side, I know as a litigant, it's almost impossible to get over your nerves to have a conversation with the judge. You're just thinking the whole time, this is a judge. I really hope they buy what I'm telling them. But we benefit when that's the tenor of the argument, and you both were really able to do that very well. I echo the points about Eric, you had a very nice beginning for us to help us latch on to what your argument was going to be about, and that helped guide a conversation. Jenny, you had the very difficult task of having to pick what the government's role would be. Normally when a government attorney comes in, they get pushed to give us the official position of the government. And if you can't do that, the judges are very upset. You, of course, couldn't do that because this is a pretend argument. And I thought you did a very good job in helping us understand, here are the limits of the rule, here are the limits of the statute, and why, why we fall in certain places on the continuum is reasonable or not reasonable. Eric, you also did a very good job of dealing with questions that try to push your position to the limits, right? You were both prepared for what I think litigants should always be prepared for, which is a judge to either misunderstand your argument or to caricature your argument, or to at least ask, what are the limits? How far is this going to go? What am I setting myself up for 10 years from now if I accept your position? And you both did a good job of looking out for that and being ready to talk about it. So hats off to both of you, and please come argue in the Fourth Circuit.
Well, congratulations again to both of you. I really have very little to add to what my colleagues have already said. I thought both of you were just so impressive. And, Jenny, first, I would say that I think you had a tough position to defend insofar as the bench is always interested in what the limit of any discretion or any kind of interpretive authority is. And so that I think was the toughest part of your argument. You didn't get defensive. You tried to answer those questions as best you could. In real life, right, there would be a dozen Department of Justice attorneys sitting around a table puzzling over that for hours and hours, and there would be some sort of, agreed upon position, put out by the government. I thought you did also an excellent job of answering questions that kind of went beyond the papers. We were remarking at how well you explained the non-delegation doctrine, which was not part of this case. But that's good. It evinces a kind of, contextualized view of where this case sits, in the midst of, the structure of government, the separation of powers, the bigger themes that are really at issue in a case like this. So I thought all of that was just really impressive. And then Eric, I thought, you also did a very good job just right out the gate of stating your position very simply. One thing that you might want to think about just for anyone here is exactly what Justice Rushing just said. Judge Rushing.
I'll take it.
Yeah. May see you promoted in your lifetime. But it's true that judges, judges are no smarter than anybody else. We're puzzling over the same problem that everyone is puzzling over. And so we may misunderstand your argument. We may miss things. We may, we may not have read like every page of the historical record on an issue. And so it's useful to come with a variety of arguments. So, oftentimes, for example, if you're trying to persuade a court that the 1882 meaning of two words really is this, well, that's fine. You should make that argument. But that can be a hard argument to win, because what do we really know, about the 1882 meaning of these? Or is it so clear, right, as to meet the unambiguousness test, right? So these are, so you might think that you might win on that point, but that's a hard point, right, to win on. And so you had a number of other points too. And I thought that's very good, is you have to think about how you can have a menu of things that might appeal to different judges' sensibilities and level of preparedness and kind of proclivities. And I think that you did that very effectively. So this was really enjoyable, and I just commend both of you. I know we all do, on such a fabulous set of arguments. And if you guys were this good, I don't know about the people you vanquished to get here, but they also must have been absolutely outstanding. And so I hope that all of you who did participate in this moot court competition took away, tremendous learning experiences and feel very accomplished, because if this is the standard that you all are maintaining here at this school, you're all going to be extremely able appellate advocates. So thank you so much for this opportunity.
Great job, Jimmy.
Put this here. It's quite high. Oh. Yeah, I was going to say something really quickly. Yeah. Sorry. We've got our photographer here.